What can you do when DCF ignores during a DCF investigation a judge's order in Massachusetts? What you can do when DCF during their investigation ignores a judge's order in another court in Massachusetts is bring that to the attention of DCF. They may have DCF may have accidentally or intentionally either not received or had knowledge of that order. In a recent case I had, a mother went in and got a restraining order, not once, not twice, 3 times, where the father was found to be the abuser and the mother and her child were found to be the victim. And then the judge ordered a DCF investigation for neglect against the father only. DCF went out and did the investigation. At the end of the investigation, they supported it against the mother too, alleging she was the abuser, which victimized her now for a second and third time. What do I mean by that? The father had already abused mother. The judge had found that to be true by the preponderance of the evidence, that it was more likely than not that father was the abuser and mother was the victim and so was the child. So that's incident number 1. Incident number 2 is DCF never told mother she was being investigated and supported against her as being the abuser. So now they violated her due process rights, which means everybody has a right to be heard regarding opportunities involving DCF. But she was never told she was being investigated. So how could she corroborate, disprove evidence to disprove what was being alleged against her? And the answer is obvious, she can't. The third way she was a victim again was by the fact that if this allegation of neglect had remained in effect, she had a job that she would have lost, which would have victimized her number 4. Why? Because then she wouldn't be able to raise her child in the lifestyle that she's accustomed to, because she would have lost her job and also lost the ability to raise her child well. So when all was said and all was done, the restraining orders, which spoke for themselves, were presented to DCF when it was on appeal. And DCF, much to their credit, looked at all of this, looked at the judge's decision, who had ruled that mother was the victim, not the abuser. And much to the credit of DCF, they got it right. And they took another look at this. And they looked at all the evidence. And when I hear people badmouth DCF, I understand you're upset, you're disappointed, you're angry, but you only have yourself to blame if you don't bring out the right evidence and show DCF what is or is not truly what's going on. And I see it time and time and time again. Clients make mistakes. And they take on DCF by themselves, which is the biggest mistake any of the clients can do, because they don't know the policy, the protocols and procedures. And you can't claim ignorance of the law. You can't say, I didn't know, or I don't know what I don't know, because what you don't know is going to get you in trouble. And you can't say, I didn't know the time standards, so I didn't know what I was doing, I didn't know how to do it. That's not acceptable. And when the evidence is what it is, and you've got the evidence, bring it. Bring it so it's looked upon in the most favorable light towards you. And if you don't, you only have yourself to blame. You can't later say, DCF, you screwed me. No, they didn't screw you, you screwed yourself. You gotta show DCF all the cards. You can't sit on the evidence. And you gotta know what to do with it, and how to present it, and make sure that DCF understands it, and push the right buttons to get the right people to do the right thing. And when you do that, you will get the right decision. DCF absolutely positively wants to get it right. And so do you. So you're really on the same page, but you gotta give them the goods. You gotta give them the right evidence. You gotta make sure you prepare and present it in the right fashion. And then good things happen.